present For the Record.
Just ahead, one Wisconsin woman's journey to get an abortion after Roe fell.
Shock. I couldn't believe it. I probably took like 3 tests.
Plus, how Madison is cracking down on threats to their election officials.
That behavior is not okay.
But first,
both at the federal level and in Wisconsin, there are calls to try to reinvigorate this doctrine.
Welcome to For the Record. I'm Naomi Coles. The Wisconsin Supreme Court has been pretty busy the last couple of weeks, releasing a slew of major decisions impacting policy in the state. We're going to dig into 2 decisions today. They were released the same day earlier this month. And for that, I am joined by the University of Wisconsin Law School's Professor Rob Yablon. Rob, always good to see you on the show.
Good to see you.
So let's start with the ruling that ended the use of Dropboxes in Wisconsin. With Dropboxes used for years in the past, were you a bit surprised by this?
Well, this was one of those cases that, could have gone either way, given the current court in particular. The issue here was that although Dropboxes had become pretty well established, there was nothing in Wisconsin's election laws that explicitly authorized them. And so the challengers here argued that without that explicit legislative authorization, they just shouldn't be allowed. Those who were defending the Dropboxes instead took the position that when the law was silent, discretion fell to the Wisconsin Elections Commission and the local clerks who have the job of actually administering elections to decide whether, properly safeguarded ballot boxes were appropriate. And here the court essentially took the position that if the law doesn't specifically authorize it, it's not allowed.
Outside of the legislature actually passing a law to put it into Wisconsin state law, is there any other opportunity, a higher court, that could possibly revisit this decision?
Well, this is a state law question, and so the Wisconsin Supreme Court is the final word on issues of state law. There are some federal law issues, though, that are lurking in the background, and we could see some future litigation about those. In particular, the Americans with Disabilities Act and some other federal statutes protect the rights of disabled individuals to access the franchise. And so to the extent that the lack of ballot boxes or a ruling that prevents individuals other than voters themselves from delivering those ballots, to the extent that that hinders the voting rights of covered individuals, they may have future claims that they can bring.
I want to pivot to another major decision. It was actually released the same day earlier this month. It allows public health officials to continue setting orders without a sign-off from an elected body. So is this as big a win for public health emergencies as it might seem like at face value?
Well, what this decision means is that the kind of public health orders that we've been seeing during the COVID-19 pandemic could continue if this pandemic worsens or during the next pandemic. So in some ways, this decision is really just one that preserves the status quo that we've gotten used to over the past couple of years. A decision going the other way, in many ways, would have been a bigger deal. It would have meant that local health experts, no matter how bad a public health emergency wouldn't have had the ability to do things like limit public gatherings, to put in place mask requirements, and so on.
And kind of relevant to the decision we just discussed, in this case, it's very explicit in state law, is it not, that public health officials can do this?
Yes, and in this case, there were 2 types of arguments that were raised. The first, the challengers did argue that public health officials at the local level did not have the statutory authority. But as you say, the law was fairly clear that they did. And so the court rejected the challengers' argument on the statutory grounds. But then the challengers also said, okay, well, if they have that statutory power, we think that it is unconstitutional for them to exercise it under what's known as the non-delegation doctrine. And this is a constitutional principle that suggests that there are limits to the amount of policy-making authority that lawmakers can give to government administrators to help carry out and implement the law.
I want to talk a little bit further about the non-delegation doctrine you mentioned, on which this lawsuit was partly based. Are there any comparable examples anywhere else in our state law or elsewhere where this is like an active doctrine that's used to interpret and apply the law?
So this is a doctrine that has not been very active either in our state or at the federal level in many decades. For the most part, courts have given legislatures a fair bit of discretion to decide how much authority they want to delegate. Now, both at the federal level and in Wisconsin, there are calls to try to reinvigorate this doctrine. And the implications of that for the functioning of government could be pretty serious. It would mean that that lawmakers don't have as much discretion to allow those who are sort of on the ground making decisions about public health, about air and water pollution, about workplace safety, and other issues to actually kind of have the discretion to implement the rules that they would need to make to do their jobs fully.
Is there anything specifically that we should be keeping an eye on in the coming months or years where you feel like this doctrine might be resurrected to apply to a certain law or certain area?
You know, this is something that it seems like it is on the table, again, both at the federal level under the U.S. Constitution and in Wisconsin under our state constitution. So Justice Hagedorn specifically wrote in this case, Becker versus Dane County, to say that he was open in the future to revisiting the Wisconsin Supreme Court's non-delegation precedents. And so although in this case he ruled in favor of the authority of the local public health officials, there may be future cases that that reach a different result.
That's a fairly significant note and sets us up for what I want to get to next, talking about the justices behind these decisions. So, as I mentioned, these rulings, they're issued the same day, and in some senses, one could argue that one is a victory for conservatives, another is a victory for liberals. Yet the same justices voted in the same way on both decisions. As you mentioned, Brian Hagedorn, he was the deciding vote on both of these. So this gives us quite the contrast, does it not? Is it a surprising contrast?
Well, look, we have a highly polarized state Supreme Court. There are 3 very reliable conservative votes. There are 3 pretty reliable liberal votes. Justice Hagedorn is a judicial conservative, but at the same time, he is no question the court's swing justice. You know, he is someone who will not move in lockstep with political conservatives in quite the same way that the other conservative justices sometimes seem to.
All right, Rob. Again, thanks so much for taking a few minutes this morning.
Good to talk to you.
All right, when we come back, threats to election workers and what Madison is doing to address it.
For the Record, sponsored by MG&E, your community energy company.